Hello, everyone, and welcome to our latest ALTA Insights webinar. I'm Jared, ALTA's Vice President of Communications, and thank you for joining us today as we have a couple of industry experts who are going to be breaking down some of the most important recent and ongoing lawsuits affecting title insurers, agents, and settlement service providers. Before starting, I always have a few housekeeping items to review. A copy of today's presentation will be emailed tomorrow, as well as with a link to view the recording of today's presentation. Anytime you have a question, please submit them in the questions box. We'll hold some time at the end for Q&A. I do need to thank Certified for sponsoring today's webinar. And before introducing today's speakers, we have a short message from Certified.
The first time I came across Certified is because we at a prior company had an instance of wire fraud, and they jumped in and were so incredibly helpful. I became a lifelong fan at that point in time. Certified has been a huge part in preventing wire fraud and helping us protect our customers over the last 3 years. If I were starting a new title company today, in no world would I consider a technology package that did not include Certified.
All right, thank you for that message, Certified. And let me move a few things on my screen here. Got the presentation showing. All right, I'm going to introduce today's speakers. First, we have Cheryl Coward. Cheryl is National Agency and Midwest Underwriting Counsel for WFG National Title Insurance Company. Cheryl has over 30 years of industry experience in many aspects of the business, including underwriting, search, examination, and residential and commercial escrow. Also joining us today is Monica Gilroy. Monica is the founding principal and managing partner of the Gilroy firm. She has more than 30 years of industry experience and has extensive lead counsel trial experience and frequently appears in all of the state and federal courts of Georgia. I was reviewing your two bios, and I feel like we probably could have spent maybe about 30 minutes talking about your backgrounds, but I condensed them. I apologize if there's other things you wanted to highlight. But I will mention both of you are on ALTA's Title Claims Council, and we had a third speaker that was going to be joining us today, Annie Malave, First American, but unfortunately she got called for jury duty today. And with that, Monica, I'll turn it over to you.
Great, thanks so much, Jeremy. And it's so great to be here with everybody here today. It's awesome to be here with Cheryl. Yes, our third amigo, Annie, if you're ready for this, is actually sitting to see if she's going to be picked to be on a real estate related case. I, of course, said, dude, I would totally pick you if it was me as a trial attorney. So Cheryl said someone's going to either want her or not want her. So we're sad that she's not here. If for some reason she's released, she may pop in, but we certainly appreciate her civic duty. So I'm going to kick it off first. And what Cheryl and I and Annie are going to do today is probably familiar to many of you. We're going to talk about a series of cases that are very, that in our opinion, are important to the industry and are bringing forward concepts or trends that we might be seeing in other places. So I'm going to start with a case out of Florida, out of the 2nd District of Florida. It's called Victor Christ, solely in his official capacity. It's the Hillsborough County Clerk versus the defendant as a Manhattan Palms Association 1 case. This is a case, just as an overview, about sovereign immunity, the clerk, and the missing letter N. N is in Nancy. So in our facts, as we see on the screen here, in 2008, Mr. Nelson purchases 2 separate parcels of real property in Hillsborough County, down there in Florida, and each parcel had a mortgage from Regions Bank with separate mortgages. The mortgages were properly recorded, but as happens sometimes, the clerk didn't properly index them. One of the parcels was under the name, Mr. Gerland's name, or I'm sorry, Mr. Nelson's name, but the one that encumbered, that one was fine, but the one that was encumbering the parcel that Manhattan Palms, the defendant on, or I guess appellee on appeal, subsequently purchased, had a misindexing. The N at the name of Nelson was omitted. So the index simply said N-E-L-S-O. And that, of course, is going to be the facts that lead us to the problem. Jeremy, can you do the next slide, please? Thank you. So here's where it all begins. Manhattan Palms goes and they buy the property at auction in 2022. As sometimes happens, about a year or so later, the property was sold to a third party. There was a tax sale, and that tax sale yielded about $138,000 of proceeds. So Manhattan Palms, thinking that they've got a priority position, files the claim for the surplus in April. But in May of 23, Regions is like, well, we're filing our claim, but it actually was for a little bit less of the surplus. So of course, right after that, 2 months later, because Regions, of course, is in that first priority position, right? And Manhattan Palms didn't know that because of the misindexing. The clerk sends the proceeds directly to Regions, and Manhattan Palms is squeezed out. So of course, litigation ensues. Jeremy, the next slide, please. So Manhattan Palms sues the clerk, and it's kind of novel. They sue for negligence, right? So if you go back to law school lawyers on our phone call, duty, breach, causation, damage, and they're basically saying, hey, if the clerk had, correctly indexed this mortgage and hadn't dropped the N, basically we wouldn't have even purchased the property, because why would we want to buy something that's encumbered ahead of us, right? And the plaintiff is arguing that, look, this duty of care is, not to the public generally, but to someone just like us, right? That somebody just like Manhattan Palms that would have a specific interest in this land, that we would be like a bona fide purchaser. You owe us independently, Manhattan Palms, a specific duty. And they make such a big deal that, it would never have even have had them purchased the property had that N from Mr. Nelson's name been included on there, and that because of that breach of duty, the clerk, causes their proximate and actual damage. All right, go ahead. Jeremy, next slide. Now the clerk, sort of on the defense side, says, look, we have sovereign immunity, right? You are suing a government, you're suing a county clerk in a tort action, and you've got to show that me as the clerk, right, breached some specific statutory duty I had to Manhattan Palms individually, right? Not some kind of duty that's owed to the general public, right? That I've got to have something that I did specifically for you, right? And what the clerk did is they basically said that, the omission of that letter N, that missing letter N, that is when the clerk, placed it into the index, but that placement, that act of doing that, right? The only duty that they have is under this statute that we see right here from the Florida statute, section 28.222(2). So basically that is the statute that just explains how the clerk is supposed to record things. It's just a basic statute that you're going to see in many states. And about that the clerk has to maintain this index. But if you look at it, friends, there's nothing in there that says, and you need to index properly, right? So the concept is that the clerk was like, look, my missing letter, our missing letter N is we still did everything we were supposed to do from that general statutory duty that's there for everybody in Florida who's looking at the title records. Let's go to the next slide, Jeremy. They also argued the clerk really stuck it to Manhattan Palms a couple times in their arguments. And they said, look, you must not have conducted a title search for the encumbrances, which you could have done, Manhattan Palms, right? You only searched by name. You lazy searched, right? If you had searched the legal, for example, it would have found the Regions Bank encumbrance, right? So the clerk files a motion to dismiss, basically based on sovereign immunity grounds, failure to state a claim. The court denies it, and the appeal ensues, with the clerk taking the case up to the Florida Appellate Court. Jeremy? Okay, so basically the court's review of there was a lot of discussion in the case about prior case law. And they did find the overall holding is that the appellate court found that the clerk's duty to index the public record under that section I just talked about is for the benefit of the general public, not for an individual. So sovereign immunity bars the action. But the court has almost 2 pages of discussion about a case that had the opposite finding. It was First American of St. Lucie County versus Dixon. It was a 92 case. Now in Dixon, same kind of facts. First American sues the clerk after losing a suit for failing to discover an incorrectly indexed what they called it in the case a claim of interest in land. And the court in Dixon went to great lengths to talk about, well, the recording of documents is to basically help an intended class of specific individuals with that property, right? And so in Dixon, they were finding just the opposite, that the general indexing and recording could be specifically just for one individual person and not for the general public. Can we go to the next slide, please? So the Dixon court was, again, in opposite of this. It found that the clerk's handling of each document, is something that is specific to that marketable title that's being searched. And part of the thing in Dixon that the Christ court made a big deal of talking about was that the clerk basically in the Dixon case just kind of fell on their ground like a bug in the air, and we're like, yeah, our legs are in the air. We screwed up, right? It was we made a ministerial mistake. We should be able to be sued because the supervisor that they acknowledged in the clerk's office that there'd been a failure to properly index the notice of the claim. And this court, the Christ court, kind of goes back and looks at Dixon and says, well, when you kind of look at that holding in Dixon that there wasn't sovereign immunity, isn't that really because the clerk just conceded? The clerk said, yeah, we messed up, we owed this duty. And the Christ court went to great lengths to show that Dixon is the only case in the Florida statutes or the Florida case law where you had a recovery like that against a government entity for a public's record error, and there hadn't been any case since. And so there were no such concessions in this case, in the Christ case, like there were in the Dixon case. So because of that, the court found that they were able to distinguish between the two. Can we go to the next slide, please? So Dixon did hold that the clerks owed a special duty to bona fide purchasers, but in our case, right, Manhattan Palms didn't even make that argument. Remember, Manhattan Palms, and that may have been sort of the mistake of their attorney, their whole premise and their whole argument was, if we had found it, we never would have purchased it. And so because Manhattan Palms says, well, the injury is stemming from the purchase, that's another distinguishable characteristic from Dixon. Let's go to the next slide, please. So the court's analysis was, Manhattan Palms, you're losing. You can't show that your specific rights were affected really by the act of the clerk, the mistake, which occurred way back, like this case is July of 25, way back in 08, when everything was recorded and indexed, albeit misindexed. And that, again, it failed, that argument fails of, because I couldn't find it, I'm harmed, right? They didn't buy that. And again, going back to the Dixon case, Manhattan Palms, did admit that they wouldn't have bid on it, they wouldn't have bought it, but it's not part of that discernible class, right? That Dixon was so focused on. They were more focused on individual members looking for something. And the clerk basically at the end of the day owed no duty because Manhattan Palms was just part of the general public. Let's go to the next slide, please. So the ruling basically is that the clerk had satisfied all of its duties under that statute when they properly recorded it, that the mixed indexing was barred by sovereign immunity so that Manhattan Palms could not recover against the clerk. And what we have procedurally was the appellate court vacated the trial court order, remanded it for an entry of an order dismissing the case, and then in the Florida statutes certified a conflict with Dixon. One of the reasons why the three of us thought this was an important case is because we've been seeing across the country more and more cases where people are taking the clerks to task. I have one here coming out of Georgia that's mentioned with the citation below, Ground Floor Holdings of Georgia versus WFG, and that's a problematic case for a variety of other reasons. But it really, these cases are almost finding that these misindexed deeds almost create certain notices in and of themselves, meaning it's not our problem, Mr. Title Examiner, if something is misindexed, because you should be looking other ways. So we had some concerns, right, Cheryl, about is this creating like constructive notice or something like that? So I think we just have to be very conscientious of these cases that are dealing with the clerks themselves. So that's the first one. That's me.
Thanks, Monica. And we are seeing trends where the courts are seem to be ever expanding what they call the duty or the responsibility of the title company or the title examiner and what the definition of public records are and what they should be looking for. So great case. Thanks, Monica.
Yeah. Hey, Cheryl. Cheryl,
Yeah.
real quick, I want to interrupt, and I know Monica, we said we'd handle Q&A at the end, but this isn't a question, it's more of a comment that Jim Russick posted in the comments. He said that the case has been certified to the Florida Supreme Court because of conflict with Dixon, and that FLTA is plans to file a notice of intent to file an amicus if the
Okay.
case is accepted. So
Excellent. Thank you, Jim. I'm glad. Thank you so much, Jim. That's excellent. That's good to know. So that'll really be one to watch then to see which side that comes down on. Thanks,
Absolutely.
Jim.
Normally, we wouldn't accept comments from Mr. Russick, but I guess this time we'll make an exception.
We can make an exception for that. Yes.
Okay, so my case, Genesis Financial versus Commonwealth Land Title, a case out of New York. This is a case in which there's a discussion over what the consideration is for a mortgage, and depending on the consideration of the mortgage, what you have as far as title policy. So facts. So in June of 2020, or June, not 2025, June of 2005, which apparently was over 20 years ago. I find that very hard to believe. Monica and I were, 5 years younger. Loft on South, through Charles Savula, purchased property. They did this with a partial cash payment, and the remainder was a seller carryback. The same day, the LLC also executed a second mortgage to Adirondack Real Estate Holdings. Adirondack at the time obtained a lender's title policy, and their second mortgage was recorded in July. December 7th, or December of 2005, Adirondack then assigned it to Genesis Financial, our plaintiff in this case. And in 2009, the original seller commenced an action to foreclose, alleging his mortgage was in a superior position. Next slide. So while the foreclosure case was pending, Genesis then commenced this current action to obtain damages, alleging that Commonwealth's failure to represent Genesis in the foreclosure action, as well as an indemnity under the terms of the policy. So the court determines that the mortgage held by the original owner has priority over the plaintiff, the Genesis. Commonwealth moves for summary judgment, asking for dismissal based on the invalidity of the second mortgage. So if you're paying attention in the initial facts, you may have noticed that when it was purchased, that they did a seller carryback. So then when they did their second mortgage, it would have maybe clicked with what were they giving? What were they giving for the second mortgage if they did a seller carryback for the remainder of what the purchase price was? So Commonwealth moved for summary judgment, saying that the second mortgage was invalid, resulting then, of course, the title policy being invalid. Plaintiff opposes, cross moves. The court granted Commonwealth's motion, denied the plaintiff's cross motion, and dismissed. Next, yeah. So, which is where we are now because they, of course, appealed. So the court's analysis, which is that a mortgage, I always like it when we get a Black's Law Dictionary quote, makes my heart warm. I know. Mortgage conveys an interest in real property as security for performance of an obligation. So if there's no valid consideration in exchange for a mortgage, then if the mortgage hasn't been established, the party has no interest in the property. So if there's no underlying debt, the mortgage lacked consideration. If there's no insurable interest in the property, then how do you have a valid title insurance policy? So no consideration tendered, no mortgage lien on the property, no mortgage lien on the property, no enforceable title policy. The court affirmed the lower court's decision. I thought this was, that's fine. Thought this was interesting. I just think it was fairly straightforward, but the fact that the court was we always like it when the court seems to understand title insurance policies. That's always nice. But also that it's very clear, look, even if you purchase the title insurance policy, if there's no consideration for that mortgage, there's no basis for that insurance policy. So it's not enforceable. So we thought that was interesting. This was by the New York, I can never get it straight. Monica, you may be able to help me here because they have their it was the appellate court, but I don't remember what they call it in New York. They sometimes call it the Supreme Court. Anyway.
I don't know. I actually don't know, but I know what you're talking about. So.
Yeah. But it was the appellate court, and I didn't see anything to indicate that that Genesis was going to appeal this decision. But it was very clear that they, by having no consideration for their mortgage, that they did not have an enforceable title policy.
You know, Cheryl, the other thing that bothered me about this case is that then that, could create also, really questions of fact about, is it valid consideration? Is it invalid? Was it sufficient? So, it
Right.
sort of triggers, you could just see a bunch of different scenarios coming out of that. But yeah, I thought that, I think it really,
Yeah, I think if you get something that's not quite as black and white as this one was, where it was very clear that there was literally no consideration for that second mortgage because that seller carryback was 100% of what was left of the purchase price. Yeah, you're going to have a conflict. The facts are going to be very determinative. It's a Monday. All right, next slide. Because I think the next, next one's mine also. So BMO Bank versus, I'm going to say Mr. Z, because there are a lot of consonants there, and I am not going to be able to pronounce that. So this was a case out of Illinois. I found this interesting because it deals with comparing a revolving line of credit, or as we think of as a HELOC, and statute of limitations also, and credit line or line of credit, but also credit cards. So facts here, in 2008, the plaintiff, BMO Bank, and the defendant, Mr. Z, executed an equity line of credit and secured by a mortgage for residence in Chicago. The agreement was a HELOC up to $100,000, 10-year term. Specific terms, your standard terms, right? Credit advances, finance charges. Also, provision that if Mr. Z failed to make the repayment, the bank can terminate the credit line, require full payment of the balance. Mortgage had similar language in it. Next slide, please. So over time, so keep in mind that the maturity date was 2018. Over time, the 3 letters were sent to the defendants by the bank. There was one in 2020 letting him know that the servicing had gone to somebody else. And there was a second letter in 2022 saying, wait, we're taking the servicing bank back. And then one a month later in 2022 in August saying that it was a first notice on his delinquency. Then in October, a year later, the bank filed a foreclosure action saying that that Mr. Z had failed to pay his outstanding indebtedness by the maturity date of 2018. And as of 2023, still owed just under his $100,000, including interest and penalties. Next slide. So in response, Mr. Z filed a motion to dismiss, claiming the foreclosure was barred based on statute of limitations. So he argued that this was the same amount due in 2013, which was more than 10 years due prior to the current complaint, and that he had not made any payments since June of 2013. I mean, which is pretty amazing. I'm trying to figure that out. The plaintiff claimed the filing of the foreclosure was timely because the cause of action didn't accrue until the maturity date of 2018. And so they're both looking at, in Illinois, the statute of limitations on this mortgage is going to be 10 years. The circuit court granted the motion to dismiss by the defendant, stating that they measure the running of the statute of limitations from August of 2013. The bank appealed, stating that the circuit court found that it accrued 2013, the past due date in the delinquency notice letter that was referenced in August of 2022. Lots of letters and dates here, rather than 2018, which is the maturity date. So the bank is arguing, no, the statute of limitations should have run from 2018, not 2013. So they were still within the 10 years. So courts generally look to the statute of limitations of the underlying debt. So they found the appropriate description is the revolving credit line. And the court did drill down on this and looked at the plaintiff arguing that the statute of limitations, since they looked at this as a mortgage. This is a revolving line of credit, but it's a mortgage. This is treated as a mortgage. Yes, it's a HELOC, but we filed a mortgage lien on the property. Defendant is arguing that the statute of limitation is only 5 years. The court drilled down on this and said, look, we have looked at all of this. All of these terms under these agreements is similar to a credit card. The credit card agreements are, although not identical, they're both revolving line credit loans under the law. You have similar situations where, next slide, go ahead, next slide, I'm sorry, next slide. Similar situations where, you know, even though there may not be a separate contract created each time with the credit card company, each time you use it, it's a contract. Each time you use your credit card, it's a contract. So actions involving credit cards have 5-year statute of limitations. So to be considered a promissory note, the agreement must provide for payment that is unconditional, absolute, and must be have a definitive or definite fixed sum according to the Illinois Appellate Court under their statutes. So they looked at both of these, they drilled down and they decided, look, it may be a HELOC, it may have a mortgage lien on the property, but what they really determined was this is really just like a credit card. So your statute of limitations on this is going to be 5 years, not 10 years. Next slide. So agreement in this case was silent as to how the defendant was to pay. Again, they're looking at this like a credit card, and it didn't specify how much the defendant had to borrow. So the court's like, look, when does the statute of limitations start to run? Is it 2018 or 2013? Now, as an attorney, I'm not always very mathy, but whether you're doing 5 years from 2018 or 2013, you're pretty much already out by statute of limitations on both time frames. Next slide, please. So they're both out, right? And the plaintiff's cause of action is time barred. So the circuit court's affirmed. I will say this, first of all, it's a great way to get 100 grand not to have to pay back. I mean, it's a good gig if you can get it. But I do think that it's interesting because we have not seen this in all states. So this is going to be very state specific, but I do think it can be it's a trend. I reviewed this case for Kansas last week. They do have a 5-year statute of limitations, but it's in the statute as a 5-year statute of limitations, and it's specific to HELOCs. But if you are in a state that has conflicting statute of limitations, this is something to pay attention to, because if you have a HELOC, a lender may fight this battle, and the statute of limitations may be shorter than what the lender anticipates it to be. So I also think it's a cautionary tale for everybody listening out there who might be drafting loan documents too. Yeah. That you better be sure you really understand in your state, you know, what language needs to be in documents, what statutes, like the fact that sounds, Cheryl, like the fact that we had that indefiniteness of payments and things like that, that's what kind of recharacterized it too. So yeah, I think this is another good reminder, a good take home for folks who are drafting those or training people who draft those, just to be really conscientious of what the laws are in your state. So well, and it's also very typical of maybe the left hand not knowing the right hand. I mean, BMO sending out letters. Annie's back, yay. BMO sending out letters, you know, after the date of maturity. So, you know, I don't know that was particularly helpful to them, but they didn't address that. But the bottom line is, yeah, be very aware when you're drafting loan documents and reviewing loan documents with a specific statute state in your state. So we got to ask. They clearly didn't want you because you were a real estate attorney, right? Right?
Yeah, so jury duty is always fun. I was not sitting on the panel. I was in the gallery for the time, and they did ask a couple of questions. They didn't ask if anybody was an attorney, but it was a real estate case. It sounded really interesting. It was realtors on both sides arguing about the exclusivity of a contract and all sorts of questions. There was they were expecting that trial to go 7 days.
Oh my, I would have
So,
picked you.
yeah,
I'm telling you, I
yeah,
would have
so
picked you.
I didn't make it, but
to be
real estate litigation alive and well.
To be fair, to be on a jury where the realtors are fighting each other would have been very interesting.
Yes, entertaining.
I think it would have been great, but yeah, they just didn't.
Well, I think you came at a perfect time because I think the next case is one of yours.
Yours.
I don't even get a chance for a breather. So the next couple of cases that we're going to talk about have to do with taxes. And, you know, honestly, who doesn't love a good tax case? Taxes affect everybody, every state, there's no question about it. And sometimes people get into trouble with taxes, and that's what brings us to the first case here. 257 through 261 20th Avenue versus Roberto. This is a case out of New Jersey, was heard by the New Jersey Supreme Court. And it was heard after Tyler. And I'll get into Tyler in a minute, but some of you may remember Tyler being a huge case a couple of years ago out of Minnesota. So to start off, Roberto owned a mixed-use property. He had actually purchased the property back in 1997, and he held on to the property and over the years obviously invested in it. At the time of this tax foreclosure, it was estimated that the property was worth about $535,000. He had no mortgage, no other liens on the property. And unfortunately, he failed to pay a $606 sewer tax bill. Whether that was an oversight or what it was, why he didn't pay, the court didn't go into that fact, but the city of Patterson did file tax liens. And plaintiff 257-261 20th Avenue LLC purchased these tax sale certificates at auction. Now you got to fast forward 11 years because it's a little ridiculous to foreclose, I guess, on $606 and some change. So they waited 11 years. And then they filed their tax foreclosure complaint. At the time, Roberto did not file an actual answer in the case or redeem. And the reason why he didn't redeem, the court does point this out in its opinion. At the time he approached the court, shortly after receiving the complaint, he did not have the funds. He had about $9,000, whereas the tax amount was well over $9,000 at that point. So he didn't answer, he couldn't redeem at the time, and so the court entered a default judgment in favor of the plaintiff with a total redemption amount of close to $33,000. So within about 2 months of the court's entering of this default judgment, Roberto moved to vacate the judgment and permit his redemption under Court Rule 4.50-1. Every state pretty much has a rule like this. Anytime a default judgment is entered, the court can vacate that default judgment if there are certain circumstances that are met. And in this case, Roberto did meet those circumstances. A couple of the reasons why he presented under the exceptional circumstances provision of this rule, he actually posted at this time $50,000 in escrow. He stated how much, and I guess he was able to demonstrate how much he had invested in the property since his purchase, and also that he was age 75. And this particular property was very crucial to his retirement, as it had, you know, several $100,000 in equity beyond what taxes were owed. So next slide, please. So the court granted that vacation of the judgment to Roberto, and of course 257-261 appealed. While that appeal was pending, that's when the United States Supreme Court decided Tyler versus Hennepin County. That was the Minnesota case that held that the government violates the takings clause of the Fifth Amendment when it keeps surplus value from a tax foreclosure sale. So what is surplus value? Simply, it's the home equity that is there beyond the tax debt. So in this case, if you want to run the numbers, he owed about $32,000 on this home. The property itself was worth an estimated $535,000. If this were Tyler, what would happen is the state would be able to keep all of that equity above and beyond that $32,000. And that was the case here. Plaintiff was arguing that as the purchaser of the tax sale certificate and the entity that foreclosed, they should be allowed to keep those funds. So what happened? When the plaintiff appealed, it went to the New Jersey Appellate Division, who affirmed the trial court's decision, relying in part on Tyler. So then plaintiff petitioned the United States Supreme Court to review that decision. Next slide, please. So what did the Supreme Court of New Jersey have to say? Well, first, the primary issue before the court, and the court did talk about a couple different issues, but for our purposes here, the primary issue before the court was whether the New Jersey's tax sale law, prior to its 2024 amendment, which incorporated the Tyler holding, violated the Fifth Amendment's taking clause. And that's an important point because Roberto was not foreclosed on under the new law. The new law did provide specific protections to New Jersey property owners to avoid a Tyler-like situation. But he was pre-2024, so the court was only looking at that statute. What were the plaintiff's arguments in this case? The plaintiff argued to the court that New Jersey's pre-2024 tax sale law did not violate the takings clause because first, New Jersey did not recognize a protected property right surplus equity when the equity in Roberto's property was taken. Second, as I alluded to before, plaintiff felt that private lien holders, which is what they were, they're not state actors. So how could the takings clause possibly apply? And their third argument was that lien holders' due process rights, so entities that purchase these tax sale certificates and then try to foreclose, their rights would be violated if Tyler was held to apply. Next slide. So what did the court say? Well, the New Jersey Supreme Court agreed with the appellate division's conclusion that Tyler applied. It was binding precedent from the Supreme Court, and it applies to cases on direct review in state court. So what does that mean? Well, direct review means that the case is still pending. So whether it's in appeals or whether it's actually pending at the trial court level, the case is still pending. It's not a final judgment. The period to appeal for vacation or to appeal the substance, that time has not expired. So that was one of the main things the New Jersey Supreme Court emphasized in its ruling. The Tyler applies because this case is pending. It does not apply to cases that are already closed and completed. And also, the court decided that New Jersey's pre-2024 tax sale law, which allowed for the state or a tax sale certificate lien holder to keep the surplus, is unconstitutional, as it does violate the takings clause of the Fifth Amendment. So another interesting fact about this case, you can go to the next slide. Another interesting fact about this case is that, I already talked about this, is that there were several amicus briefs. So plaintiffs' arguments were actually supported by the National Tax Lien Association organization, as well as the New Jersey Land Title Association. And in their briefs, they raised a lot of policy concerns, suggesting that if they just vacated this judgment, it would jeopardize the stability of title insurance. It would decrease the likelihood of tax foreclosures and undercut the ability of towns and cities to generate tax revenue. Roberto also had some support in the form of amicus briefs of the Pacific Legal Foundation and Legal Services of New Jersey. And for those of you who are familiar with Tyler, Pacific Legal Foundation was actually the organization that represented Ms. Tyler in the case. And they argued that Tyler applies in New Jersey as much as it does in Minnesota, and that private lane holders are liable as state actors because of their role and their participation in the tax foreclosure process. It's not that they are the government, but by buying a tax sale for certificate and stepping into the shoes of the government, that is what makes them a state actor. Legal Services of New Jersey also asserted that New Jersey does recognize a property right in surplus equity. So what did the court do? Well, like I said, the court did rule in Roberto's favor. And as you can see on this slide, it addressed each one of those plaintiffs' arguments in turn. It found that New Jersey property owners do have a recognized right to the surplus equity. And they based that on various historical and legal traditions in the state of New Jersey and recognized that that right was compensable under the takings clause. The court also reasoned that Tyler provides that the takings clause protects property owners from a taking of their equity without just compensation. And that applies regardless of who is doing the tax foreclosure. The court agreed essentially with Pacific Legal Foundation that yes, when you have these tax schemes where tax certificates are sold and a private entity can buy them and then foreclose, they're kind of stepping into the shoes of the government. And that's the law. It is allowed, but essentially you're getting a pseudo state actor, if you will, but it's still kind of the government's, the government is trying to enforce their right through a private actor. So the third thing, and I really like that the court spent some time on this fact, was that the court declared that the government cannot confer greater rights to a third-party purchaser than the government actually has. So the whole argument about being a private lien holder and the government can't keep the surplus, why would a private lien holder be able to keep that? Because just like in real estate, you can't convey more than you own. So when the government gives a tax sale certificate and that person goes to foreclose, they can't claim or get more than what was actually owed to the government. And like I said, I really like the fact that the court pointed that out in this case. So next slide. The good news is in New Jersey, Tyler applies, Roberto won. I hope he's enjoying his retirement. Okay.
Annie, do you think this is something we're going to see in other states? Do you think this is, is it happening, Cheryl and Annie, in other states?
Absolutely, it's happened in a lot of states. A lot of states, once Tyler came down,
yeah,
a lot of states took the initiative and took a look at their tax sale foreclosure statutes. And they did try to remedy that to avoid another Tyler-like situation. And what we've seen in other states is that, you know, you had these cases that were in the pipeline during Tyler. So we're seeing these nuances come out like we saw in New Jersey, where in this case, we had a private lien holder making the argument that they should keep the surplus. Whereas in Yono, the argument, again, is slightly different with some different facts, but very similar. I think this might kind of get toned down because how many cases were in the pipeline before Tyler that have not gotten to that final judgment stage? So I think we're going to start to see a decrease in these cases and possibly see other arguments being made on these post-Tyler statutes that have been passed and are now being enforced. All right. So Yono versus County of Ingham took place in one of my favorite states, Michigan. And what happened here was Yono had owned some commercial real property in Lansing, Michigan, and he failed to pay his taxes for a total of $17,500 and change. It's amazing the difference in these tax prices, state to state. So the Ingham County Treasurer foreclosed on the property, and under their tax sale statute, they offered it for sale at public auction. Unfortunately, the property failed to sell, and the treasurer deeded the property to the defendant, the Ingham County Land Bank Fast Track Authority, we're just going to call that the Land Bank for short, for $1. I think that is the fact that hurts the most. Lost the property for $1. So Yono, obviously upset at this, sued in 2020, alleging defendants took his property without just compensation in violation of the Michigan Constitution takings clause. And it's important to note, and I'll talk about it a little bit later as well, that he did not raise a specific claim under the United States Constitution's Fifth Amendment takings clause. So what happened with Yono? Well, at the circuit court level, the circuit court ruled in defendant's favor on a summary judgment motion, and they were relying on a prior Michigan Supreme Court case known as Raffaelli LLC versus Oakland County. And the primary holding in that case was that there was no taking in a tax sale foreclosure because there were no surplus proceeds from the sale of that property. And I do apologize, I just noticed that mistake on the slide. No surplus proceeds from the sale of proceeds. That makes no sense. Okay, sorry about that. Okay, next slide, please. Okay, so Yono then appealed. And at the Court of Appeals level, the Court of Appeals concluded that Raffaelli should not be the controlling case because Raffaelli did not consider what would happen if the real property failed to sell during a foreclosure sale. And that's kind of like the dividing point on this case. This is plaintiffs arguing that is a controlling fact, and the defendant, Ingham County, was arguing that, hey, this is whether or not it sells at a public auction is indicative of its fair market value. So the Court of Appeals did reverse and remand the case to the circuit court for further proceedings to determine the property's value. And the court's rationale behind that was that there had to be some sort of taking that the takings clause was designed to prevent based on the property having some value, because every piece of property has some kind of value. The defendant, Ingham County, not liking what the appeals court had to say, appealed to the Supreme Court of Michigan. Next slide. So the Supreme Court of Michigan, the primary issue was whether there was actually a taking when the government forecloses on the real property and that property fails to sell at public auction. So Ingham County argued that, Yono argued that Raffaelli was not controlling because, again, that property sold at public auction. And because his property failed to sell at private auction, he was arguing that another case decided by the Michigan Supreme Court, Jackson versus Southfield Neighborhood Revitalization Initiative, should control his case. And in that case, they held that there is a taking, notwithstanding a lack of proceeds, when the foreclosing government unit did not offer that property for sale. And that's an important distinction that the court really relied on. In that case, there was no foreclosure sale at all. There was no public auction. There was no public notice. In that case, the government entity simply transferred the property to another government entity. Next slide. So the overall ruling was that the Supreme Court of Michigan agreed with the Circuit Court, the original ruling, that Raffaelli applied, and they reversed the appeals court decision and reinstated that Circuit Court decision. Next slide. Why did the court say that? Well, as I alluded to before, Raffaelli held that the violation only occurs if there are surplus proceeds from the sale of the property at public auction. They emphasized, I think they said it a couple times, Cheryl, you reviewed this case as well. They said it a couple times that the foreclosing government unit is only required to return proceeds in excess of the delinquent taxes, interest, and penalties that are reasonable, and other fees, which I would imagine would include the fees for the lawyers to go and actually make the foreclosure complaint, and the sale of the property. No more, no less. So in this case, because the government did place that property for public sale, the sale is the correct metric to determine the value. And in this case, even if the property doesn't sell and remains in the government's possession, it's what that fair market value is. What was the price? And here we just didn't have that. We had, next slide, we had no proceeds. Whoa, wait a minute, there was supposed to be another slide.
That's fine. Yeah, I mean, the argument was, you know, we sold it for $1, right? We hinged on that. They sold it to the land bank for $1. Public auction, they got no bids. Where the appellate court relied on the, I think it was the Jackson case, where they said you have to take into consideration basically what an appraised value would be, or like a fair market value in the real, you know, world, so to speak, would be versus what we're going to get at a public auction. And they came down and said, no, Raffaelli is the correct precedent to rely on here. And I think that's probably accurate. I mean, you can't expect these courts to go down the rabbit hole, or I would hope you wouldn't, of going, okay, well, now you have to go out and get appraisals and determine what the equity might be in these in these properties, when we tried to sell it at public auction and nobody bought it.
Exactly, exactly.
Makes sense.
Which given the rash of tax sales at the moment, I find hard to believe. So
True. True.
One of the things I think the Yono case kind of begs the question: what if he made the argument under the federal Constitution?
right.
And you know, we can't predict what a court can do, but we can try to reason it out. And I think the fact that there were no surplus proceeds, I mean, that's the bottom line. There was nothing there.
And what
And
are they going to get back? There wasn't anything
Exactly.
to get back.
exactly. And the fact that this was a public auction.
Right.
It's
Right.
not like, you know, it was clothed in secrecy and nobody knew about it except for the 3 realtors in the room. You know, I mean, it wasn't anything like that. There was nothing shady about what happened here. So, I mean, even if he made the argument under the U.S. Constitution, I think there's a strong possibility that the result would be the same.
I mean, the bottom line is pay your taxes.
Yes,
Yes.
even though they apparently seem to be much higher in Michigan than they do in New Jersey.
You're the person that can tell us about that, because you've lived both
Well,
places.
you know, well, here's the thing. In the New Jersey case, it was just sewer taxes assessed by the city of Patterson.
Right.
Okay.
Yeah, that was
Michigan is actually real estate property taxes.
Yeah.
So I think that's part of the difference. And
Yeah.
when you look at property tax bills in New Jersey, yeah, they're a lot more than Michigan. I mean, just overall, I think Roberto's case of $606 in sewer taxes, that's just an oversight, dude. But
Yeah, $606 that ended up being over 13 grand. So
Yeah.
Yeah. You just gotta wait long enough. Let the interest build.
Yeah.
Okay. So I see we're kind of short on time. I do apologize for that. I am going to do my best to get through Strobel versus Oklahoma Tax Commission. This is a case that comes out of the Oklahoma Supreme Court. Quick run on the facts. Alicia Strobel, she is a member of the Muskogee Creek Nation in Oklahoma. And in December of 2020, she filed for a refund of her personal income taxes for the tax years 2017 and 2019, claiming her income as exempt. So the Oklahoma Tax Commission's Audit Services Division looked into that and notified Strobel that she did not qualify for the exemption, because in order to qualify, all 3 requirements must be met. So first, you have to be a tribal member. 2, you have to live within the boundary of the reservation. And 3, you have to work on Indian land to which you are a member of. Next slide. Okay, so she appealed that, and they went to an administrative hearing in front of a hearing officer for the tax commission. And Alicia presented evidence demonstrating she was a member. She was employed by the legislative branch of the tribe during those years. And her office, when she worked for them, was on land owned by the United States in trust for the Creek Tribe of Oklahoma. She also provided evidence demonstrating she lived in the city of, I'm gonna screw this name up, Okmulgee, Oklahoma. For those of you that live there, I'm sorry if I mispronounced it. And this particular city is located within the external boundaries of the Creek Reservation as defined by the Treaty of 1866. Now, one undisputed fact that all of the concurrences in the dissent pointed out is that it was undisputed that Strobel's home was located on unrestricted, non-trust private fee land, which she acquired from a non-tribal grantor in 2008. Next slide. So what happened? Well, the administrative law judge agreed with Strobel and recommended that the Oklahoma Tax Commission grant her protest and refund those tax amounts. The Audit Services Division of the Commission then filed an application for an in-bank hearing claiming that their own administrative law judge messed up. That on-bank hearing was held and found that Strobel did not live in Indian country as defined by the tax regulations for the purposes of this state tax exemption and denied her protest. So Strobel appealed to the Oklahoma Supreme Court, arguing that McGirt versus Oklahoma established that the area that she lived in was actually within Indian country. Next slide. So what was the issue? The issue before the Supreme Court was whether or not Oklahoma could impose a tax on a Muscogee Creek Nation member who lives and works within the boundaries of the reservation that were recognized in McGirt. Okay. And what does that mean? That's I'm going to try to explain this the best way I can. So treaties were created under a variety of treaties way back in the day. And over time, land was sold and states may or may not have recognized the boundaries. Land was sold to people that were not of Native American heritage, and it was put on the county books. And for a very long time, people just accepted that. And what happened in McGirt was a criminal attorney argued that for the purposes of the Major Crimes Act, we should be looking at the reservation boundaries as they were set by treaties. Not necessarily where we think they are, but where they actually are by treaties, by what Congress said, and maybe what previous courts had said. And for the Major Crimes Act, that they did their best to say that that was it. But here's the problem. Indian country is defined under the Major Crimes Act, and there's 4 very specific definitions that fall within the kind of gamut of Indian country. The Supreme Court of Oklahoma did not create its own definitions. They pulled the definition from the Major Crimes Act, put it in their regulation, word for word. So you can see that that would cause some confusion as to what is the definition of Indian country. If you're using the same definitions as in McGirt, why would it be different because Oklahoma's looking at it as opposed to a federal court? The dissent made valid arguments regarding that point and several other points. But unfortunately for Strobel, the Oklahoma Supreme Court in a 6-3 decision held that she did not qualify for the state income tax exemption under the Oklahoma Tax Commission's regulation. Next slide. Now there was a per curiam opinion, and even though it was 6-3, not all of the judges agreed on the reasoning. So there were actually, you had the per curiam opinion, and then you had 4 concurring opinions that all used different legal reasoning to reach their ultimate conclusion that the United States Supreme Court's decision in McGirt did not extend to the state's civil and taxing jurisdictional authority. The dissent in this case reasoned that there's a long line of United States Supreme Court cases that holds the Major Crimes Act definitions for Indian country apply in civil contexts. And next slide. And this case is over over people. It has been appealed to the United States Supreme Court. Strobel filed that petition in September of 2025. The Oklahoma Tax Commission filed its response in December of 2025. Now, the Supreme Court, I checked the website just the other day. They are still deciding whether or not to hear this case. They're still in conference about it, but we should have a decision soon as to whether or not they're going to take the case. If they decide not to take the case, then the decision of the Oklahoma Supreme Court stands. If they do take the case, we might have a very interesting opinion coming to us soon. So,
But at least for right now, it didn't extend McGirt, so that's
it
Right.
did not extend McGirt, no.
at least for right now. Yeah.
Any questions?
All right. Well, thank you for breaking down what's driving these cases. Apparently, you guys said pay your taxes and you can avoid some of these issues.
Especially the $600 sewer one.
Pay your
Oh my
taxes,
gosh.
For
people.
real, the sewer one, yeah.
I mean, that's like, it seems like it's like just 6 months. It's like just, did you not get the invoice or what? The bill in the mail?
He was an older gentleman. He was 75, so.
Okay, all right, understandable. All right, anyway, a little bit of time for Q&A. If you don't have a question right now, next slide actually has contact emails if you want to reach out. Again, a reminder, if you missed parts of today's webinar or you think others in your office would benefit from listening, a recording of the presentation will be emailed tomorrow, and you can always access all of our webinar recordings at alta.org/webinars. Not seeing any questions come in, so I guess you guys all just wowed everyone. I was curious, none of them dealt with fraud, and it seems like we're talking a lot about fraud in the market. Are you guys seeing any other cases that we didn't talk about today that are looking at fraud, and you've seen any trends percolate up in the courts about that?
And I'm seeing a lot of it live while it's happening. I mean, we're seeing
Right.
just an influx of the fraudulent cancellations again, the lender cancellations, which just, I thought everybody could have figured that one out by now, but I think it's so, the technology is just evolving so much, but we're still seeing that.
Yeah, we're seeing it on the claim side, definitely.
All right, well, I guess we'll wrap up. I need to thank Certified once again for sponsoring today's webinar. And with that, thank you for you three for lending us your time and your expertise and walking us through these court cases. And with that, that'll bring us to the conclusion of today's presentation. Take care, everyone.
Thank
Thanks,
you.
Jeremy. Bye, everybody.
Bye.
I'm glad you didn't get picked, Annie.